remiss not thanking you for inviting me and thanking you for sponsoring an event like this on these issues. But second of all, it's a sad week for us in Hudson Valley, and I think we would be remiss as a group in not taking notice that we're losing really one of the great leaders in the country on progressive issues. Our congressman, not my congressman personally, but many of our congressmen were essentially. And I think that his passing from the political scene is going to create a very big void. Because realistically around the country there may be 5 as progressive congresspeople in America who've been on many, many issues willing to raise a voice. So I think that one of the things we need to do in the next number of months is figure out how we're going to deal with that. Because as you're going to hear, the issues which we're talking about need exposition, they need champions. The public doesn't pay a huge amount of attention to some of these issues, and if we don't have elected officials, and we have very few of them, as you all know, who are willing to stand up and deal with these issues, they go, at the end of the day, very, very, very little place, to use a non-English phrase. All right, let me try to set a brief picture for you of what I see as a constitutional lawyer with regard to speech issues. Because to speak about one decision out of context is a disservice to all of you. You have to see the breadth and context of this Supreme Court and its views about speech. Because we're talking about one form of speech, but there are other forms of speech, and you'll hear, I think, some of the profound inconsistencies between this decision and some others. And I think that's really, in a way, at the heart of the class message that this is about. Before the Citizens United decision, in 2006, we do have competition here, the Supreme Court of the United States decided a case called Garcetti. How many of you people in this room have ever heard of Garcetti? 1, 2. Do you have any idea what it's about? The 2 have heard of it? No. Okay. Garcetti is as important a decision as Citizens United. Garcetti is as important a decision as Citizens United. This is what Garcetti says. If you're a public employee, a teacher, a firefighter, a police officer, a post office worker, anybody who works for any level of government, state, local, or federal, you just basically lost your protection to speak out about matters of public importance. Okay, that's Garcetti. That's Garcetti, 2006. In that case, the district attorney of Aurora County in Colorado fired his deputy. He fired his deputy because his deputy made public comments about a police investigation which had eventuated in the arrest and conviction of individuals. That was totally bogus. The investigation was totally bogus. People went to jail. The deputy district attorney blew the whistle. Woo, woo, what the hell are you doing? And he went public and he went to the newspaper, and guess what? He was right. And guess what the county district attorney did? Off with your head. Goodbye. Now, the speech was a matter of clear public importance. That someone's had been innocently convicted. A search warrant had been obtained through perjury and forgery. And this man had the courage to blow the whistle and say, wait, wait, wait. And he was fired. Fired, punished, off with the head. Lost his career. And the Supreme Court of the United States said the firing is perfectly okay. Because that man had no constitutional right under the First Amendment to do what he did. Why? Because his speech really related to his employment. And speech that relates to your employment is not constitutionally protected speech. So a firefighter in New York City who finds asbestos in the fire company and goes to the New York Post and blows the whistle and says you have asbestos that's in this fire company, it's a health hazard. He's fired. You're disrupting the fire company. You're disrupting the fire company, just like that assistant district attorney disrupted the political aspirations of his boss. You're fired. Goodbye. And he goes to the U.S. District Court and he says, that's a violation of my First Amendment rights. All I did was go to the New York Times or the New York Post and tell them about this asbestos condition. That's a matter of public importance. How can I be fired? That's my free speech. The Supreme Court said, goodbye, we don't care. It derives from your employment. It really isn't it's related to your work. If it's related to your work, it can't be a First Amendment protected. And can you imagine this?
Why didn't we hear a lot about it?
Well, that's what I'm asking you. Why didn't you hear a lot about it? You didn't hear anything about it. The two of you in a room of 35 people even heard of it. And there are some public employees I know in here, friends of mine. They never heard of that. I don't talk about these things in social context, so they don't even know that. The point I'm making is simply this. When you look at jurisprudence, you can't look at one case. You look at one case, you're missing it. You're missing the whole thing. Because that's not what it's about. That's not what the American legal system is about. It's not about one case. It's about a set of values that are memorialized in a series of cases that, frankly, stretch across lots of areas of the law. Do you know you can't desegregate schools voluntarily now? How many of you know that? A school district like Monticello, if it said, we have racial concentration in one neighborhood, we don't like that, we don't want that to be in our schools. So we're going to adopt voluntarily a program to desegregate our school. And a white parent comes up, or a black parent, they say, we don't want that. No, 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 no. You can't take our race into account at all. And the school district says, what are you talking about? The future of our country, we have racial diversity. We don't want to have segregated schools. The Supreme Court of the United States, the same year as they issued the Garcetti decision, said to Seattle and Louisville and a number of other communities, cases consolidated before the Supreme Court, you can't take race into account at all. Meaning, you can't desegregate your schools. That's what the decision says. How many people knew that before today? Don't be shy. Everybody knew it. One person knew it. Okay? 2 people knew it. Good. Now you're informed people. You're progressive people. You're people who want to make social change. This is what we're dealing with. So when you start looking at this, I'm with you on all this, but it's just a really small part of the picture, frankly. It's a really small part of the picture. The picture is a Supreme Court which is radically rewriting American constitutional law with judges, almost all of whom came from Mr. Bush, all of whom went up to the Congress and said, I believe in stare decisis. What's stare decisis? Precedents. I believe in precedent. I believe in precedent. I believe in precedent. I'm not going to overturn precedent. BS. Most of you have heard that word. BS. Okay? There's no regard for precedent. Now, Citizens United is another example of no regard for precedent. Nothing. Precedent is a term that we in the law use for decisions that have been made, and because we want something of a stable legal order. We don't keep changing fundamental principles. Because if you have a constitution, and every few years you say it means something else, what does it mean? It's meaningless. What do we have a constitution for? Now, that doesn't mean the Constitution doesn't change. Privacy rights, rights to contraception. Contraception wasn't constitutionally recognized until the early 60s in the Griswold case. Before that, states could say, you can't have contraception. If we want to restrict you, married couple, whoever you are, we're allowed to restrict you. There's no right to privacy.
They're still trying to do it.
I agree with you. They're going backwards. But what I'm trying to say to you is until the late 50s, early 60s, that was the law. They could do it. States' rights. They could do what they want. This presidential election, without digressing too much, is fundamentally turning into a debate about the locus of power in America. That's what it's about. Does the federal government regulate central areas of our life, which means limits the states to what the states can and can't do? Or do we elevate the 10th Amendment? You know, Gingrich just made Rick Perry the head of his new 10th Amendment committee. The 10th Amendment committee is a code word for states' rights. And in the South, you know what states' rights is still a code word for? I practiced law for the Justice Department and then for the NAACP National Office for 10 years, from 78 to 88. I was in the South almost every day. It's the same code word it was in the 1950s, folks. Guess what? Newt Gingrich is writing it. He's writing it against Barack Obama, imperfect as he may be. He's writing it against him. Okay? So we're in a context. And I'm frankly, as a thinker, against elevating one thing out of that context and making it be the most important thing. He said, it isn't the most important thing. It's something important. But there are a lot of important things going on right now. A lot. Public employees have no right to speak. They have no whistleblowing rights. Federal government has basically said, through our Supreme Court, no. So I want a constitutional amendment about that, because I think it's really important that the millions of public employees who speak out and should be encouraged to speak out about corruption, fraud, abuse, brutality. I had cases for correction officers in these counties, Sullivan County, Orange County, Ulster County, who were in federal court because they had spoken out and blown the whistle and had been fired. You know what happened to those cases? Flushed down the toilet. No protection. So that's a very, very profound issue. In education, it's a profound issue. We have a district Ellenville, some people from Ellenville are here. We have teachers, guidance counselors, social workers who are constantly coming forward and revealing things that are extremely negative about conditions in the district. That information is very important to prompt change, to fuel change. Those people can be fired for doing that. They can be fired for doing that. The school district can come and say, we're bringing them up on charges because they're disruptive. And they're speaking out. We're prohibiting them from speaking out. We can do that. Okay? Now, let's talk a little bit about Citizen United. That's what you're here for, not about all the rest of this, but I'm trying to put it in context, okay? The